versus Thomas Archer. That's case number 18CA0010-M. Each party will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know and I'll keep track of the time for you. As you both probably know, the arguments are recorded and posted on the court's YouTube channel, so we ask that you keep your voice up and remain at the podium. I don't believe, let's see, are there children involved in State versus Archer?
There are, the victims are children.
That's what I thought. Okay, so the court has a rule that we refer to them by their initials and not by their name. The court has read the briefs and are ready to proceed if you are.
Thank you, Your Honor. Good morning, Your Honors. I'm Attorney Ronald Spears on behalf of Mr. Archer. I'd like to say good morning and thank you all for your time and consideration. Frankly, I've done this for 20 years, and the only time I get nervous as an attorney is when I see you guys walk in the room. So please forgive me and let me do the best that I can.
It's all right, it scares us too.
Thank you, Your Honor. Your Honor, this was a case arising out of Medina County. It was a case in which the defendant pled to reduce charges as outlined in our facts. As the case proceeded, there was a switch in attorneys. That switch caused a hesitation in the defendant to have the new attorney review the information. That switch also came halfway through the defendant's pre-sentence investigation. After I was engaged as trial counsel, the discussion was had, he proceeded to sentencing. He was sentenced by the Court of Common Pleas here to a maximum prison sentence for each count.
Will you be reserving time, by the way?
Yes, Your Honor, we would.
How long would you like?
Reserve 4 minutes, Your
4
Honor.
minutes. All right.
We believe that the sole assignment of errors the trial court imposed a sentence contrary to law would be in violation of 2953-08 by sentencing the defendant to maximum prison terms of 5 years. This is in light where the defendant had no prior felony record, had never previously served a prison sentence. We also believe that the trial court failed to consider that as a less serious factor under 29-29-12C3 and a recidivism less likely factor under 29-29-12E5. We would submit to the court that it is clear factually that he pled to these 2 counts, that at elocution he considered all the things that had happened, all the things that were done, and accepted responsibility in front of the judge that day. In my elocution, also suggested to the court his true remorse, the fact that he maintained his guilty plea. I understand factually in this that the question of him considering a change of plea, in the exchange with the court that the state outlines, the court was trying, because once a switch was made with counsel, counsel requested a continuance so that he could properly advise the defendant based on his independent view of the actual facts and circumstances of the case, not necessarily an outright objection to continuing with his guilty pleas. We had that discussion, and he decided to do so. The exchange from the court was because the court knew that that was being considered, and I believe the court clearly in that transcript is making sure that there's no doubt that this individual wanted to proceed to a sentencing. That was the last opportunity for him to do something other than that. He then proceeded, and as our position, proceeded to clearly accept responsibility for his conduct. The concern here is that statutes give the court certain requirements to consider. And I understand that they don't have to make specific findings as far as supported by individual facts. However, if just saying the magic words that I considered that, but yet a person in his class with no prior felony record, no trip before that to prison, for that person to receive maximum, it would appear that there's just two types of individuals that would be sentenced in that situation. Him getting a maximum sentence, and someone who had committed a felony or had served a prison sentence. The only thing that would be left would be a maximum consecutive sentence. I believe that the sentencing statutes clearly suggest that a court should take into consideration a myriad of sentences based on the myriad of different defendants that would come before them. If this individual was not considered for a community control sanction or a non-residential community control sanction or a combination thereof, or a sentence less than the maximum, who could possibly be considered for that type of sentence? We've now removed that placement or that gap in the law. We've taken it away because the only other individual from our perspective would be a person who had no prior criminal history, not even misdemeanors, because he pled guilty to an offense that required some type of punishment. And I would argue that the sentencing statutes are set up so that different individuals with different histories, different levels of conduct, different times in prison would be slotted in the 6, in the 9, 18, 24, all the different sentences that you could get for this elevated felony in the 3rd degree. It appears clear that no other, we would argue no other defendant could have received a lesser sentence. So I think that by this sentence and by this conduct, it appears that there was just saying the words that comply with the statute is one thing. Considering the facts and applying them to those statutes is different. I think that it is set up this way so that we don't have predetermined sentences. And then those predetermined sentences are wholly accepted because they say those words. I would suspect it to be the other way, that there not be a predetermined sentence, that a true weighing of all the factors be had, say those words, and then present a sentence that's based on that entire view. And I think...
Counsel, can I interrupt you just for a
Yes,
second?
ma'am.
I'm sorry. But weighing all the factors, let's assume we weigh all the factors, there would be some that even thought maybe this sentence was light. I mean, I understand that's all he could be given, but considering the conduct that he pled guilty to.
Yes, Your Honor. And
I mean, you've got 2 little children.
yes, Your Honor.
His own children.
Yes, Your Honor. And our position on that would be still the same, is that you have to undertake an analysis of those factors. And the legislature didn't say, in all of these cases, you must include a maximum sentence. And they have in other areas of the law. Drug laws, they have said, you got to do 11 years if you're convicted of this. They clearly still allow a non-residential all the way up to a maximum consecutive sentence.
Well, in this case, wouldn't the maximum sentence have been a consecutive sentence?
No, Your Honor. I believe that under this analysis, our position is one count, he received a 5-year sentence, which is the maximum sentence for that count. Second count, he received a maximum sentence. And though they ran concurrently, there were still maximum sentences pursuant to that charge. We believe that a maximum consecutive sentence would suggest another analysis all on its own. We believe that this is separate from the analysis of maximum consecutive sentences. We're not alleging that the court gave him all the time that was possible. We're alleging that the court imposed 2 sentences that were maximum sentences for those individual counts.
Of course, the court could have done 2 or 3 years on each one and run them consecutive, and he would have had a lot more than what he has now.
Yes, Your Honor, we cannot.
Because there were 2 separate victims.
We cannot deny that, Your Honor. Our position, with all due respect to that possibility or that potential, our position would be that would still invoke a different analysis for us, but it does not diminish the analysis that we think that our position, our argument, the court failed to undergo the appropriate analysis in this instance. So based upon that review, Your Honor, we believe that the court should undertake the 2-prong test. Your Honor, we believe that because of what our suggestion is, which is just a not full and expected review and consideration of the requirements of the law, that prong 1 and prong 2 are met. We would ask the court, obviously, in that instance, to find for the appellant, Mr. Archer, that we would ask the court for an order to send this back for full review and a resentencing on that.
Does your argument suggest that findings are required by the court, or reasoning for imposition of a sentence is required by the court?
I don't believe that that's the current law, and
Current laws, they don't need to make those
right.
findings.
What I would suggest, though, is that the current law still seems to suggest that there should be consideration of those factors, which is obviously, Your Honor, with all due respect, different than actually making them on the record have those findings.
4 minutes.
Thank you.
Good morning, Your Honors. May it please the court, I'm Vince Vellucci with the Medina County Prosecutor's Office. On behalf of the appellee of the state of Ohio, the assignment of error, the sole assignment of error is that the sentence of 60 months, 5 years is contrary to law, is the way it's phrased. First of all, it can't be contrary to law because it's within the sentencing range for an F3 sexual battery and an F3 gross sexual imposition. In terms of if we look at it as supported by the record, the trial court did not have to make any specific findings, as was mentioned, or give any specific reasons for its sentence. We know that. That's not the law. In terms of the 5 years being the maximum sentence, I think Judge Carr has it exactly right. And the suggestion was that it could have been 10 years. They could have been run consecutively. Even if each one was less than 5 years, you could have run those consecutively and been more than 5 years. So this is by no means the maximum sentence that he could have gotten, especially given the heinous nature of these crimes, as was mentioned. You've got a 2-year-old and a 5-year-old who were Mr. Archer's children. I cannot imagine a more heinous or serious 2 F3s that there are. Archer mostly attacks the PSI report more than the sentence itself. He claims that the report should have included the recidivism not likely factor of showing genuine remorse. The fact is he showed the opposite of genuine remorse throughout this case, despite what he may have said at the last minute at sentencing, the self-serving words he may have spoken at sentencing. On the record, he actually admitted that when probation had interviewed him for the PSI, he still denied committing the crimes that he already pled guilty to. He admitted that after pleading guilty, he had considered for a long while withdrawing his guilty plea and wanted to withdraw his guilty plea for a while. Going all the way back to the investigation, Archer told police that he did nothing wrong. He said that he was being set up, in fact, by the mothers of his 2 victims, who he said were just out to get him and out to ruin his life. He claims that the PSI report should have included the less serious factor of no physical harm, but the PSI actually doesn't include information either way on that factor. I would note that it's not uncommon for sexually abused children to suffer some sort of physical harm, however minimal. However, I think we all know that the primary harm from sexual abuse of young children is psychological. The trial court stated in its order that it did in fact consider all of the seriousness and recidivism factors. That's what it had to do, and that's what it did under 29, 29, 11, and 12. Stated that. The court did not go through each one individually. It didn't have to go through each one individually and explain if it was for or against Archer, whether it was for or against him. Archer seems to presume, without any evidence, that the court just adopted all of probation's recommendations without even thinking for itself. There's absolutely no evidence of that happening here. He seems to almost be appealing the PSI report more than the actual decision of the court.
I'm assuming the pre-sentence investigation report is part of the record.
I believe Mr. Spears moved to make it part of the record. I had thought it was made part of the record, but I was just speaking with Mr. Spears before we came on here, and he seems to think maybe it was not made part of the record. So I'm not entirely sure on that. In any event, the trial court sentence is strongly supported by the record. Like I said, it would be hard to imagine 3 more serious third-degree felonies. Sexual assault of a 2-year-old and a 5-year-old who were this man's children. Speaking of the seriousness factors, 29, 29, 12B1, you look at the victim's injuries being exacerbated by their very young ages here. If you look at B2, at sentencing, you had the mother and the grandmother of one of the victims who laid out the huge psychological injury that was caused to that victim as a result of Archer's crimes. If you move to B6, Archer's relationship with his victims clearly facilitated these offenses. And if you look at B3, Archer was in a position of trust, clearly, being their father. I would say Archer also demonstrated a likelihood to commit future crimes. Under D2, which looks at the criminal history, it's true he didn't have any prior felonies, but he did have a history of 2 domestic violence charges that were ultimately reduced to disorderly conduct, I believe. He also had a fairly extensive juvenile delinquency history. I believe he had 2 juvenile delinquencies and 2 unrulies as a juvenile. And then under D5, the no genuine remorse, I would just reiterate again that there was no genuine remorse shown here. We're just going to have to disagree on that. But I think, like any court would, the court here considered Archer's consistent actions over the course of this case and over the course of the investigation, and considered them over his self-serving words at sentencing. The sentence wasn't clearly and convincingly contrary to law. That's the standard. Wasn't clearly and convincingly unsupported by the record. I'm not even sure we have an argument on that second part, but it's phrased as contrary to law, which it clearly isn't if it's within the statutory range. Given all these factors, the sentence was very much supported by the record. In fact, lucky it wasn't more severe in terms of the length of this prison term.
So in terms of clearly and convincingly contrary to law, as the felony sentencing statutes continue to change, so is it the state's position that as long as it's in the range, it's never contrary to law?
I think it has to be, it has to clearly be against what a statute is telling the court to do. So I don't think that's the only situation where it would be contrary to law, but I think that's the most common one. It's the only one I can think of at the moment. But generally, if you're within the statutory range, then you're not contrary to law, is what I would say. I'm not willing to say that's 100% always the case, but
Yeah, I know, it's a tough question, right? Because you're talking about appellate review of the trial judge's sentencing factors and what the appellate court can and cannot do.
yes.
state's position on that? Can you answer the question?
Generally, I've seen the focus be more on the second part, that clearly and convincingly unsupported by the record. I think that sort of gives you more leeway and generality in terms of the things you can argue. You can go to the whole record and say, well, this, or this makes it not supported by the record. But so I would just ask this court to affirm the judgment of the trial court. Thank you.
Thank you. And you have 4 minutes to move on.
Yes, Your Honor. Just to very quickly address, we had previously filed to supplement the record after leave. The court granted it. The court struck the manner in which it was filed, and it's my understanding that the probation office now, as we speak, has complied with supplementing the record.
All right, thank you.
Yes. Just want to make that clear. Every time I'm in court, I stand beside someone who has done something that many people in the community think are heinous, horrible, unforgivable. The truth is that many of those individuals in the beginning don't come to grips with what they're accused of or what they've actually done. That sometimes true remorse happens over time. Sometimes true remorse happens when they speak with family, they speak with attorneys, they're confronted with evidence. But the truth is, it doesn't say true remorse from the beginning or true remorse in the middle. There's no timetable on true remorse. It's
So in this case, the remorse was maintaining his plea of guilty, or was there more than that?
Yes, Your Honor. We believe that he, at his sentencing elocution, informed Judge Collier that he was sorry for his conduct and for his actions, and that he was embarrassed by his conduct and his actions. And I would suggest, Your Honor, not withdrawing his plea is a component of that true remorse also. I have clients who are on video shoplifting, and you show them the video, that will look at me and everyone else in the courtroom and deny that that is them. So I believe that the refusal to accept any responsibility can go beyond reason. But yes.
And so what you're saying, we probably do have the PSI at this point?
Yes, Your Honor.
Okay, so
yes.
According to the state's briefs in the PSI, he actually confessed to forcing oral sex on his son and touching his daughter's vagina.
Yes, Your Honor.
So I guess I'm just not understanding the argument about remorse, because he faced life in prison if he had been convicted of rape.
Yes, Your Honor.
That sounds like a smart decision, but I don't know that it's a remorseful decision. Can we maintain his guilty plea?
I would submit to the court both. A wise decision and a remorseful decision. Just as heinous as this court believes his conduct is, and the state believes his conduct is, and we all believe his conduct is, saying in an open forum that you did it, there has to be some remorse or ability to accept some responsibility to do that, because it's not admitting to driving drunk, it's not admitting to have a crack pipe, it's admitting to what everybody here thinks is a heinous crime. So, Your Honor, we would respectfully ask this court again to remand this to the Board of Common Pleas in Medina County for review and a resentencing. Thank you very much.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. The courts will mail a copy of the decision to both counsel on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website if you want to check in there. Thank you both again for your arguments.